Hello, everybody, and welcome to our webinar, How to Reduce the Risk of a Nuclear Verdict Against Your Company. We've all heard about the rise in nuclear verdicts affecting the trucking industry, and with all the information floating out there, it can feel really overwhelming and even unactionable at times. So we're here to tell you today just how to help unmuddy the waters and tell you that there are things that carriers can do to protect their company. Just really quickly before we get started, please know that the webinar will be recorded. You will receive a copy of the recording to the email address you used to register for the webinar within the next 24 hours. If you have any questions at all during the webinar, please don't hesitate to ask them. You can type those into your GoToWebinar questions panel, and we'll address them at the end of the webinar during our live Q&A session. We also have a couple of handouts that are going to help you along the way under the handout section in your GoToWebinar panel, and we'll help you remember these as they're referenced in our presentation too. So today we'll be covering the following agenda items. We are going to give a general clearinghouse update on common misconceptions and additions to our service that we offer. We're going to follow that with what a nuclear verdict is, its impact to the trucking industry, what you need to know to reduce the risk of a nuclear verdict for your company, and then a view into what the industry is doing to litigate reform. So my name's Leah Kelly. Today I'm here with Shannon Wheeler, Tenstreet's General Counsel, who's going to talk to you about what you need to know about nuclear verdicts, again, what leads to one, how they're impacting our industry, and what you can do to minimize the risk of having one against your company. And then also with us today, we have a very special guest, Jennifer Hall. She's General Counsel and Executive Vice President for Legal Affairs for the American Trucking Associations, which is the nation's leading organization representing the interests of the trucking industry. Jennifer is responsible for ATA's legal affairs and the AT Litigation Center, with both engaged in litigation to advance and protect the interests of the motor carrier industry and state courts around the nation. So today she's going to share what the ATA is doing with tort reform to try to curb the impact of nuclear verdicts on the trucking industry at both the state and federal level. So welcome, Jennifer, and thanks again to everybody on the call for joining our webinar today. We're going to get started here with Shannon's favorite slide.
That's right. So as always, we have to give our legal disclaimer. The following is for educational information only. We cannot give out legal advice. You should consult with your own legal counsel on all of the issues that we talk about here. With that said, I want to make sure that I thank Jennifer appreciate you so much for coming on and joining our webinar. It's an absolute honor to have you, and it's been really, really great getting to work with you. After having met you at the NATERA conference in Orlando, Florida, and then getting to work with you and putting this together, it's been a pleasure and I really appreciate it.
Thanks, Shannon.
All right, so in talking about a clearinghouse update, I know that that's not a part of the nuclear verdict, what you would normally think of. I will talk about it in tight end a little bit later, but there's just been so much that's happened with the clearinghouse. I wanted to do a quick overview for you, and then also point you to a blog post that I recently drafted, and it is on the Tenstreet blog. I think Leah is going to put it in the chat for you to follow. Take a look at that. It's going to answer a lot of the common clearinghouse misconceptions that we hear from the industry. There's been a lot of confusion, which is understandable as with any new regulation, new process. There's a lot of confusion, and it takes a while to get that process down. Interestingly enough, though, the Drug and Alcohol Clearinghouse put out an update that is in your handout, so you can kind of dig into that and see what the clearinghouse has said about what the results have been. There have been, which I think is incredible, 889 drivers that have registered with the clearinghouse, and 905,000, I think I might have left off the 1,000 on the drivers, 889,000 drivers, 905,000 queries run, and most notably over 21,000 violations in 6 months. This shows the chart directly from the clearinghouse on what those substances have been. Very clearly, marijuana is the biggest violation that we've seen. So that's just a little bit of an update on the clearinghouse. Please go check out the blog. It'll be some good information. And then I'm also doing a webinar for Natera on common clearinghouse misconceptions on July 23rd. So if you are interested in asking questions or being on that webinar, jump on over to the natera.org website and sign up there. Okay, we also have added if you follow the Tenstreet Compliance Center, we added clearinghouse cards into your compliance center. They are automatically there and show up, and I just love the compliance center. You can see within your dashboard exactly where you sit with various compliance issues that are within our system, and clearinghouse is one of those. So if you use us as your TPA, we can show you these things. We can show you within the last 90 days, what percentage of your hires have you run a full query on? The same with how many of those full queries have been completed. And then within the last 12 months, and you can see it's a rolling 12 months, how many limited queries have been run on all of your drivers. And so you can have this set up to email you these weekly, monthly, whatever you would like. And then you can also keep track of your clearinghouse compliance and the other compliance within our system. So I think it's really cool. Go check out the new compliance center cards we have. Okay, so let's move on to the topic at hand, nuclear verdicts. This is such a popular topic. You can't be in the trucking industry and not see or hear the word nuclear verdict these days. It seems like we are bombarded with this word and seeing these incredibly large numbers. And I really wanted to just break it down for everyone and say, hey, like what you really need to know and answer some questions on it, because I know there's confusion, and if you're not a lawyer, you might not really understand what this means and what it means for your company. It's a little bit scary. It should be, because there's a lot of money that's coming out of these. And then really, what can you do, if anything? So if you're wondering what a nuclear verdict is, it's a personal injury case. So a car wreck or accident that involves a truck is what we're talking about here. And it's where the jury has awarded a plaintiff a verdict over $10 million. There's some sort of semantic arguments over, is that really what a nuclear verdict is? Some say it's a verdict. It could be less than 10 million if it's disconnected from reality in the amount that would compensate the plaintiff. The truth is that they all sort of apply, and this is just semantics. It's a large verdict that is or ends up being devastating to a carrier. These are becoming crippling to the industry. They're often unpredictable, completely unpredictable, and there's numerous other intangible factors that go into whether it's there's a nuclear verdict, and play into nuclear verdicts, such as plaintiff's tactics, the numbers. There's been a lot of commentary on just the numbers that have gotten bigger. The juries seem to be desensitized to what that number really means, and so that has the effect of growing the numbers. And then there's there's other factors that come into play that are really outside of the control of a carrier. But my goal here is to really talk about what you can do to help prevent a nuclear verdict. So as you all probably know, even better than I am, it is having a severe impact to the trucking industry, all of these nuclear verdicts that are coming out. The American Transportation Research Institute ranked the impact of large verdicts in the trucking industry as one of its top research priorities. And then very timely in June, of this year, just a little bit less than a month ago, ATRI released their research for understanding the impact of nuclear verdicts on the trucking industry. And that is attached as one of your handouts. It is a long read, it is several pages, but it is so informative. As I was preparing for this webinar, it was really driven by the fact that we had this data from ATRI and an ability to break it down and look at what we've all been feeling in the industry, which is that these are more often, these nuclear verdicts are happening more often and they're bigger and bigger. And ATRI really breaks that down and shows that the data really supports that that's what's happening. And then Chris Spear, the ATA president and CEO, has specifically said, and I think he said it really well and the best way you can say it, which is that nuclear verdicts are strangling our industry. So you can go to the next slide, please, Leah. And they're strangling our industry, as you can see with these numbers. These numbers might just be against one carrier, but they affect all carriers with insurance rates, as I'm sure you all know. And I'm going to talk a little bit about that. But when you see these numbers, you have to think, wow, what is leading to, and what can I do to prevent these types of numbers from happening against my company? I mean, 280 million, that is at least speculated, I think is true, the absolute biggest number that we have seen yet. It was funny, first the $80 million one was the biggest, and then the $90 million one was the biggest, and then the $101 million was the biggest, and it just keeps growing. And you know, there has to be an end somewhere. I hope that there is, and I know Jennifer's going to talk a little bit about that and what we can do. But you know, we see these numbers and you think, what is leading to these? How is this happening? And are there factors at play that we can control? And I think that there are. If you go to the next slide, please, Leah. So a little bit more on the trends. You can see this is again from ATRI. Really in 2010 and 2011 is when they shot through the roof. And then it's been up and down since then. And so you cannot deny the drastic increase in the number of cases with verdicts. This is over 1 million. The research was really interesting. ATRI said that in the last 5 years, there have been 300 cases with more than $1 million verdicts. And if you think about that $1 million number, it's important because a lot of insurance coverage is typically with a $1 million limit. And when you see this many cases, 300 cases with more than 100 million, it's really clear that $1 million in coverage isn't enough anymore. And I think, let me see here, the average that was looking through some of the data, and the average verdict size, this was put out by Case Metrics, in 2012 was 2.6 million. But in 2019, the average verdict size was 17.5 million. Of course, there's some really big verdicts that factor into that, and really little ones, but 17.5 million is the average. And if you only have $100 million in insurance coverage, that's going to place, you know, 16.5 million on your company to make up the difference to pay that verdict. And that is difficult, if not impossible, for most carriers to do, which is putting carriers out of business. It's putting some insurance companies out of the market too. So that's pretty impactful. If you would go to the next slide, thank you, Leah. There has been some speculation in the legal side of things of, oh, well, these verdicts are justified based on increase in healthcare costs and increase in verdicts or in inflation. Well, we all sort of knew that really wasn't the case. It doesn't feel right that, you know, a $17 million, you know, average is because of inflation. Inflation hasn't risen that much, and neither have healthcare costs, while they have risen. This chart, again, put out by ATRI, really shows that there's no correlation at all between the health care costs, inflation costs, and the verdict size. The verdicts have just been increasing. So that leads to the question of what is happening then? Why are these occurring? And what is justifying them? And Leah, if you wouldn't mind, thank you. Insurance companies are, obviously these numbers are hitting them too. They're saying, whoa, we can't afford to continue to insure all of these trucking companies with these huge verdicts that come across. Oftentimes they're on the hook or pay a lot of those verdicts, even if it's above their insurance rates. Sometimes they don't, but sometimes they do, and they get stuck with them. So so the insurance companies are losing money directly because of the target of the trucking industry for these nuclear verdicts. Even low risk carriers who have really high safety ratings are seeing an 8 to 10% increase in their rates. But it's really the carriers that have marginal safety ratings that are really having insurance hit their pocketbook with 35 to 40% increases. And so insurance companies are really becoming selective about who they will insure and at what rate they will insure them. And we've even seen some insurance companies just completely exit the trucking industry market. So this is where, even if you don't get an nuclear verdict against your company, if the industry as a whole doesn't do something, then it's really going to continue to affect everyone. And I think Jennifer is going to talk a lot about that and what they're doing on their end, which I think is really great, and they're having some great success at. But I think also all companies sort of raising the safety level will help too. I mean, they're never going to go away. Accidents are never going to go away. Large verdicts are never going to go away, but certainly minimizing those would be the goal. So, common themes that we see in nuclear verdicts. So this is going to sort of dig into what the cases bring and what we're seeing, and that is that in every case, any case that involves sort of severe injuries, especially if there is the loss of life or amputations, multiple people with serious injuries involved, children involved. Those are the kind of cases that should be setting off alarm bells of this has the potential to be a nuclear verdict. And those are the cases that you really want to, be prepared to make some hard decisions on. But in all cases, any accident, but particularly if there are severe injuries, the plaintiff's attorneys will attack the company and its safety practices. There's a 100% guarantee of that with any accident. If it's a severe accident, they're going to point to a systematic failure at the company for having inadequate safety procedures. And they will argue that the company has put profits ahead of safety. So this is within their benefit, and this is what will get them to a bigger payout. And plaintiffs' lawyers often work together. They share tactics, they share ideas on what works. They even have books that they share with one another. They have organizations that they combine with so that they can say, hey, what works here, what works there. And they get better and better by sharing those. One of the things that we've seen, and you all have probably heard this term and thought, what the heck does that mean, is the reptile theory arguments. And you're thinking, I have no idea. Are they saying that the jury turns into alligators, or do they bring an alligator into the courtroom? I mean, that's kind of what I thought when I was like, what is this reptile theory? It actually emerged, I don't know, more than 5 years ago, maybe 10 years ago, but really before 10 years ago, you didn't see this kind of talk. But there was a book put out by a plaintiff's attorney called Reptile. And what it is the plaintiff's attorneys specifically target and appeal to the very human nature of the jury members. there's sort of this idea that there's a basic reptilian instinct that every person has to protect themselves and protect their family and community around them. And that if you appeal to that personal nature to a jury, a very emotional, personal nature towards the jury, towards them, their families, their community, that will get you a bigger award versus just talking about the plaintiff, just talking about the facts of the case. They will say, hey, you should teach this company a lesson so that this doesn't happen to you, so that this doesn't happen again to somebody that you know. So they really, that's called the reptile theory or the reptile type arguments. They really try to make it personal to the jury and bring in a lot of emotional feelings that the jury might have. They also really bring in a lot of emotion for the plaintiff. It used to be that the arguments and the amount of award that a plaintiff was entitled to was their medical costs and some compensation for their suffering, some, amount that gave them, a little bit of compensation for, having to have gone through what they went through. But now the arguments and the awards are that the amounts should sustain the plaintiff or the one or more individuals in the accident for the rest of their lives, and that, that they should be compensated really, really well and live out the rest of their life in comfort financially because of this accident. And that's a really different theory than what it used to be, and what I think a lot of the defenses would argue that it should be. So, and then they almost never blame the driver, because that they found that really backfires on them, because drivers tend to be really good, really good people and really good witnesses, and the drivers play well on a witness stand, and they just come across as somebody trying to do their job and do the right thing. And so what they'll argue is that the driver is just another victim of the company's failure to have good safety practices, and that the driver it's not the driver's fault that the company didn't train him well enough. It's not the driver's fault that the company put him in this situation. So these are some of the common themes that we see in cases. I mean, we can tell that when you hear a plaintiff's attorney talk about this, they'll often say, these nuclear verdicts are in response to just inadequate safety practices in the trucking industry across the industry, that the industry isn't safe enough, and that they are doing the public a service with these so that the trucking industry will become safer. But I mean, I think there's a lot of theories against that, and the Atri report discusses that. I think Jennifer might mention it later. It actually harms the trucking industry. It makes insurance rates go up even for those that are safe. And it makes them have less insurance coverage. And we know that, trucking companies run on pretty tight margins. And so if they didn't have resources to put into safety prior to a nuclear verdict, they certainly aren't going to have them afterwards. And then if they have insurance rates that go up, that also takes away from the resources that they can put into safety practices. So I think it actually has sort of a negative effect on the industry, but that's what the plaintiff's lawyers would say is happening here. So let's go to the next slide, Leah. And so what are some of the factors that we see in nuclear verdict awards? And I'm going to point these out, but I kind of want to preface it before I do, which is that sometimes these nuclear verdicts don't have any of these. And sometimes the nuclear verdicts aren't even where the driver or the trucking company was at fault. You know, there was I think it was a $90 million verdict against the trucking company, where the passenger vehicle actually crossed the center lane and ran head on into the truck. But what happened in that case, there was really bad weather. I think it was low visibility. And what the plaintiff's attorney was very successful in arguing was that the truck should never have been out there. Even though the truck did not cause the accident, it still ended up in a really large verdict against this carrier because well, they said, well, the driver was inexperienced, the truck shouldn't have been out there, you know, things along those lines, and just completely ignored the fact that it was the passenger vehicle that ran into the truck. And, you know, 75% of highway accidents that involve a truck are actually attributed to the passenger car. So while I point out these factors, these are really just factors that play into nuclear verdicts, but it's not guaranteed that even if you take all precautions that you're going to be in the clear. So, but fatigue is a big one. If there are hours of service violations, that's actually one of the things that played into that $280 million verdict. They said the driver had only gotten 5 hours of sleep the night before or something before he had started driving that truck. So that's a big one. You see a lot of attacks on the fatigue of the driver. Drug and alcohol violations, those are definitely going to lead to a nuclear verdict. If the driver has had previous drug and alcohol violations, or if the company hasn't done the regular drug and alcohol testing that they should do, that's, if you haven't run the clearinghouse like you were supposed to, that's really going to play into things. One of the verdicts, I'm not sure which amount it was, but the driver had actually been randomly tested and been negative, but 2 days prior to the accident had been or at least admitted on the stand that he had been engaging in illegal drug activity, and in the post-accident testing tested positive for those things. So you know, even though there was nothing that would have indicated to the company prior to that accident that you know, he had drug and alcohol in his system or a history of it, it still led to a nuclear verdict. The driving history or inexperienced drivers, that's another factor we see heavily. So if, hey, you know that your driver has had 12 previous accidents, they're going to be really attack the company on that basis. And why did you still have this guy driving for you if he had all of this, you know, previous accidents? Inexperienced drivers are the same. We know that the driver shortage is another issue in the industry. And so you're probably saying, well, hey, we've got to hire inexperienced drivers. They have to get experience some way. Yes, that is true. Just make sure, as we're going to get into in a minute, make sure that they are trained, and make sure that you are monitoring them and doing what you need to do to get them to a level where you can justify to a plaintiff's attorney as to why they were behind the wheel. Improperly trained drivers. We're going to go through some of the things here in a minute on what you can do on training, but I would say training is key, and documentation around training is going to be key for you to be able to say in one of these cases, we trained our drivers, we did everything we could to train our drivers. So training at orientation, training throughout their employment, and then training in response to incidents, in response to, you know, events that you see that happen, you know, according to either your in-cab cameras or your, you know, the technology that's on the truck. Health-related issues, that's a little bit harder. But there have been some verdicts that have had health-related issues with the drivers, and that's harder for a company to factor in, because if they've gotten, you know, the kind of certifications that they need, and hey, that this driver was signed off on, then you put them behind a wheel. Distracted driving is huge. We all know these little cell phones, they are in our hands and they're in drivers' hands too, and having a absolute no tolerance policy that is enforced for distracted driving is going to be key. And then equipment maintenance. Equipment maintenance is really, really big. If something goes wrong with the truck, which causes the accident, that's going to be, definitely something that the plaintiff is going to attack on. And remember, these plaintiffs, they go after everything. They're going to attack every practice of the company. They're going to look back through everything. They will get safety data that is publicly available. They will do subpoenas to get information which is not publicly available. They will look at all data that you have, from cameras to the speed to hard braking events to lane departures, every previous history of that driver. And then they're going to look at what the company did. What did you do when you knew this information? They'll get emails, they'll do depositions. And I heard one attorney say they love sitting down and deposing a safety director, that they know when they sit down in that seat that they're going to tear that safety director apart. And when I heard that, I mean, my mouth almost fell open. It was like, wow. So they take joy in this. Attorneys are interesting people, especially when they're doing litigation. They take joy in that, and having your safety directors and your personnel informed about what is happening in the industry and what is going on as far as training and practices that you can have in place, and what statistics say about distracted driving and things along those lines is going to be key, because they're going to be testifying for your company in a potential deposition in one of these cases. Okay, Leah, if you wouldn't mind. So kind of talked about it a little bit, but the number one way to reduce your risk of a nuclear verdict, of course, like I've said, there are other factors that are at play here, but your defense, one of the only defenses you're going to have, and the thing that you can control, is safety, is allocating your resources into safety. ATRI said, and this ATRI report said, the more safety activities that motor carriers engage in to prevent crashes, the lower the likelihood that a nuclear verdict would result. So we know that, every company would like to be perfectly safe, but you've got a lot of other things on your plate, a lot of other things that you're dealing with. But if you are concerned about nuclear verdicts, which you should be, because they are becoming a routine, regular thing in the industry, you really need to protect your company by allocating resources into safety. If you'll go to the next slide. So you might be saying, well, what does that mean? What do we need to do? What is safety, allocating resources into safety to prevent one of these mean? Well, it means that you want to have safety as your defense, that you value safety, that you try everything you can do to ensure that an accident like this doesn't happen. And you want to use that as a defense. So what that means oftentimes, and I know a lot of carriers might wince when they say this, is that you have to go above and beyond compliance with the FMCSA regulations. The FMCSA regulations aren't easy. There's a lot of them, but the plaintiffs will stand in front of the jury and say those are the minimum that a company should be doing. And if a company is doing just what the FMCSA regulations say, they're not doing enough to protect you and to protect your family. That's the argument that's going to be from the plaintiff's side. So if you really want to prevent a nuclear verdict, you got to go over and above what the FMCSA regulations say. And what they found when they poll these jurors oftentimes after a verdict comes out, after a case that's gone to trial is over, you get to poll the verdicts that each jurors and ask them what they thought was meaningful. What did you think about this? What did you think about that? And what jurors often said in cases where the verdicts were lower, or where there were, defense verdicts, which are few and far between these days, but is that the jury said that safety activities that went beyond the regulations were really meaningful to them. So if you want to take from that, the good data is that means go above and beyond the regulations. That starts with hiring. Do additional hiring practices, run background checks on your employees, on your drivers, see what their background looks like. Do a PSP. It's not required, but it provides really, really, really good data. Have strict hiring standards. When you're looking at accident incident history, you want to evaluate that driver really, really strictly, and then you have to stick to them. So whatever you set as a hiring standard, make it a hiring policy that is written, and then stick to it, and don't make exceptions for it. If you have a policy and you make exceptions for it, then that's going to give leverage to the plaintiff's attorney as well. And then throughout the time that they're driving for you, do additional monitoring, do more drug testing than what is required. The requirements have recently gone up, by the way, for random drug tests, but do more than just what's required. Do MVR monitoring so that you know any accident that driver gets involved in. Do clearinghouse checks more than required. Right now, you're required to do a pre-employment, and then there's no follow-up for another year. And so within that year time period, there could be a driver that's gotten a violation to a pre-employment test that was reported to by another carrier, and you never got notice of it because it was after the 30-day update period, after the full. And so between that 30 days after you engage the driver and the 1 year when you're required to run the limited, there's 11 months in there that there could be a violation reported. And a plaintiff's attorney, and let's say a violation was reported and you didn't find out about it and the driver's still driving for you, plaintiff's attorney is going to say, you mean it would have cost you $1.25 to find out that this guy had previous violations and you didn't do it? That will play very negatively in front of a jury. And so these are the kinds of things. Run a limited on your drivers every quarter or every 6 months, more often than what is required. The hours of service checks. If your drivers are violating hours of service, you are at risk. Those hours of service, the juries place a lot of value on that. And I think that if they think there's a fatigued driver, they're gonna not only blame the driver, they're gonna blame the company too. So please be aware of that. All right, next slide. Okay, so then also, when you're presenting safety as your defense to a nuclear verdict type case, you want to show that safety is the main priority of your company, or it's a part of your company culture, that you place lots of importance on this. How do you do that? You want to be able to show that you closely monitor company safety data, that you monitor your CSA scores really regular, and that if they're poor scores, if you have poor scores, come up with a plan and document the steps that you take to improve those safety ratings, and do what you can to improve those safety ratings. You want a documented internal safety program, and you want safety policies and procedures. And the key is that those have to be enforced. If you have the policies and procedures and you don't enforce them and you make exceptions, that will kill you. That would be worse than not even having the policies and procedures. So get those kinds of things in place and then enforce it with documentation about, hey, this driver violated the safety policy. This is what we did as a result of that. And then, like I said before, you have to ensure that company witnesses are knowledgeable about safety in the industry and common safety practices, because it is uncomfortable to sit across from a plaintiff's attorney at a deposition being questioned, and it is even more uncomfortable if you aren't confident that you know the industry practices and that you're educated. So I feel for any witnesses in a deposition, it's not an easy place to be, but it's really not easy if you don't know what you're talking about, and those plaintiff's attorneys will not make it easy. Have safety technology in your trucks, cameras, automatic braking technology, things along those lines. Those are really great data points. And then I think I said it before, training at orientation, training throughout employment, document the training that you're having, and then make sure the training's up to date. Make sure that it is responsive, which means if you have an event, a heartbreaking event, a lane change of event, or a CSA safety rating that drops as a result of something, immediately do training in response to that and document it, because those are things that you will be able to show you did as a defense, saying, hey, this driver, we tried to correct it, we gave him instant training. And then if there are enough of those incidents, you got to cut the driver loose, because a driver who's had 12 incidents in a year is going to be a liability for you. Obviously, depending on what those incidents are. And like I said, safety technology in the trucks. So like I said, up-to-date driver training throughout the employment, responsive and timely to events. So if there are hours of service violations, CSA, things along those lines, complaints that you might get, those are all things that they need to trigger a training response. And so this is the part of the webinar that I get to kind of talk a little bit about what Tenstreet's doing for this, and there'll be more to come on this, but Tenstreet can help you with this. We are getting ready to roll out some new products that can help on the safety side and help exactly with this, with training, so that you can have start having easy safety solutions to help you in a defense of a nuclear verdict. So we are going to have the ability to have your CSA score come through into your dashboard. We'll do that once a month, and that will be for all of our clients. If you're a client of ours, you can have CSA data in your dashboard updated once a month. We will also have the ability to have CSA data updated daily. So if you really want to monitor that, which should be key, close monitoring of your CSA scores, we're going to be able to have those available to you updated daily. And then even more, I am not sure if any of you have heard, but we have been doing a training. We have been doing, we have our own training content that we are putting out. Our people have been working really, really hard on that. I think we have 70 titles or close to 70 titles, and that training library is growing as well. And so in addition to being able to do training at orientation and training throughout employment, we can and will have the ability to do and send out training in response to CSA scores and CSA numbers. So that'll be really, really cool. It's in beta testing right now. We are hoping to have more information for you in our webinar, which is going to be on July 21st. So sign up for that. I think Leah is going to put the sign up in the chat. It's going to be super cool, super easy for you all to be able to have this safety as a defense. And let's see, I think I'm going to pass it over to Jennifer to talk about how and what the ATA is doing to help this problem. They're doing a lot of really
Thanks, Shannon. I've lost sound, so I'm hoping you can hear me. But thank you and Tenstreet for inviting me to speak today about ATA's litigation reform campaign. For those of you who aren't familiar with ATA, we are an 86-year-old federation and the largest national trade organization advocating for America's trucking industry, with affiliates in all 50 states. Together, our federation represents more than 34,000 motor carriers and suppliers covering every sector of the industry, from LTL to truckload, agriculture and livestock and auto haulers, and from large fleets down to the independent contractor and small family run operations. Our federation has members in every single congressional district and delivers to every U.S. community, with more than 80% of communities nationwide relying solely on trucks to move their goods. You might ask, why am I telling this to you? And it's because we're going to need to leverage that strength to change the current litigation environment. This is going to be an uphill battle. So at ATA, we strongly believe that when an accident happens and wrongful conduct causes injuries, the wrongful party should be held accountable, and those injuries caused by that conduct should be compensated. This is how our civil justice system or our tort system is supposed to work. Unfortunately, as you saw from Shannon's presentation, we have seen over several years the system of justice abused and truck accident claims and truck accident litigation being turned into a profit-making business rather than a fair system for holding responsible parties accountable. In response to these concerns, ATA is focusing on accident litigation reform. And ATA President and CEO Chris Spear highlighted this in his State of the Industry speech at ATA's management conference last October. And the association has raised this as a top priority. Leah, next slide, please. Litigation isn't going away, as Shannon mentioned, so our goal isn't to get rid of litigation, but it's to restore fairness in highway accident cases. We're looking for an even playing field, and we know that this is the early stages of a multi-year effort that will encompass all pillars at ATA. Next slide, please. In the short term, we recognize the pain being felt as carriers face insurance renewals. To address this, we are pulling together a risk management and insurance best practices document. And this will be a guide for motor carriers that will provide information on how to shop and apply for insurance coverage effectively. Additionally, we will be stepping up our educational efforts to help carriers help themselves after an accident happens. This includes a renewed focus on the Highway Accident Litigation Symposium at the ATA Litigation Center's Trucking Legal Forum, which is being held this July 20th through 24th, this year online instead of an in-person conference. You don't have to be an ATA member to attend the forum, and you can register by going to our trucking.org website and clicking on the events link. This year, sessions are going to include combating the reptile theory, using medical analytics to dispute unreasonable or excessive medical charges, empathetic resolution to claims meets aggressive litigation. Are the concepts really that different? And legal do's and don'ts when using video and coaching drivers. Additionally, we'll be engaging in a long-term, multifaceted advocacy effort to change the highway accident litigation environment. Next slide, please. As I said, this is the beginning phase of a long-term campaign, and it will include advocacy, image, communications, and coalitions. Next slide. So focusing on advocacy, we're going to focus at the state level initially. Tort law is primarily state law, and states vary a lot on how good or bad their tort law is. At the state level, we plan to pursue a threefold strategy in close collaboration with our Federation of State Trucking Associations. We plan to wage a 50-state campaign on a relatively narrow trucking-specific issue. Our target is seatbelt gag rules. So for those of you who don't know, a seatbelt gag rule, it is where many states prohibit a jury from learning that a plaintiff's injuries were largely or wholly attributable to the failure to wear a seatbelt. We will identify 2 to 3 states per year to target, and we believe we can build on early victories in relatively friendly states to bring the fight elsewhere. In addition, we're going to be working with our state trucking associations to identify and assist a number of states that are ripe for more comprehensive tort reform. What the comprehensive tort reform looks like will vary from state to state, but might include caps on damages, reforms relating to expert testimony or other evidentiary issues, or restrictions on attorney advertising and third-party lawsuit financing. This year, we worked with several of our state federation partners, and we have seen wins in Iowa and Louisiana. And ATA will be hosting a webinar on July 28th for our members that will dig into those wins. And then finally, in the states, we're going to be working closely with our state federation to coordinate increased involvement in the state judicial selection process. The Plaintiff's Bar has been for some time the biggest donor for Democratic Party candidates federally, but there are a growing number of Republican plaintiffs' attorneys in state legislatures, and the Plaintiff's Bar has devoted enormous resources to stocking state courts with plaintiff-friendly judges. So we need to do a better job of countering those efforts. While changing laws and rules to create a more even playing field is important, it is only effective if the judges that are interpreting and implementing those laws and rules are impartial. Because these are down ballot elections in the states where judges are elected, often the biggest challenge in these races is name recognition. And we think our industry has an advantage here because whether it's through terminal visits or other outreach tailored to our industry, we can help defense and business-friendly judges reach voters. Next slide, please. While highway accident litigation, as I said, is fundamentally a matter of state law, we intend to pursue relief at the federal level as well. To be clear, a federal legislative push in the current political climate with a divided Congress and during a presidential election has a very slim chance of success. Although it's a long shot, we do feel at a minimum it is worth pursuing to raise the profile of the issue at the national level. In particular, we will give participants in our Call on Washington program an opportunity to explain to their representatives in Washington just how serious the highway accident litigation crisis has become. And it will also represent how big it's become and the threat it represents to the efficient movement of freight in our nation. But in addition, we think there might be some benefit of drawing away plaintiffs' bar resources from the states to fight at the national level. And for those reasons, we are pursuing a threefold strategy at the federal level too. So first, we intend to identify a body of federal agency materials the plaintiffs' bar exploits to mislead juries about the proper standards of care in the trucking industry. An example of this is a document. It's outdated. It's a 1997 Federal Highway Administration publication back before the Federal Motor Carrier Safety Administration was created. Plaintiffs' attorneys like to inflame juries with this document, stating that a CDL does not mean that its holder is trained and experienced commercial vehicle driver, and that assuming that a CDL means that can be a very dangerous mistake. That's actually written in the document by the federal government. After working to identify similar materials with our members and the industry, we will then work with DOT to withdraw or modify these documents. Second, we're going to persuade Congress or the relevant federal agencies to shine a light on the growing problem of third-party litigation financing by requiring its disclosure. Traditionally, cases are funded through a contingency arrangement with the plaintiff's attorney. In recent years, though, we have seen third-party financing of litigation, and these financing arrangements can draw out cases and increase costs. Third-party financing firms operate largely in the shadows with virtually no regulation or oversight, in stark contrast to our industry. They're essentially issuing loans to plaintiffs at exorbitant rates, but because the arrangement is styled as a stake in the proceeds of the lawsuit, they're able to avoid regulation. So if a plaintiff doesn't win, the lender takes a loss. But if the plaintiff recovers anything, the plaintiff is on the hook for the full amount of the loan plus interest, even if the amount of debt exceeds the recovery on the case. This puts the plaintiff in a position where they are unable to accept reasonable settlement offers that would otherwise make them whole. In other words, a plaintiff that would be upside down on a reasonable settlement offer would be better off turning it down, taking the case to trial, and losing the case altogether. Lawsuit lending puts an artificial upward pressure on the value plaintiffs assign to their claims. And this represents a fundamental perversion of the justice system. So we believe that transparency of this financing will lead to additional reforms in this area. And finally, we will persuade Congress to open the federal courts to catastrophic highway accident cases. Unfortunately, we have seen that it is very difficult to get a fair shake in state courts. Going back to the reptile theory that Shannon mentioned, plaintiffs' attorneys know they can only employ this strategy if they're before a judge who will allow them to present matters far afield from the crash at issue in the case. They forum shop aggressively when bringing cases and take great pains to stay out of federal court. Congress faced a similar problem 15 years ago. Defendants in class actions were often having trouble getting a fair shake in many state courts in extremely high stakes litigation. So in response to that, Congress passed the Class Action Fairness Act, which allowed defendants in class actions worth $5 million or more to move their cases to federal court. We're looking for it to do something similar. While it won't solve the problem, it will help to even the playing field with cases overseen by judges who are appointed for life under a consistent, well-developed set of evidentiary rules. Next slide, please. public engagement is going to be a critical component of our success. So ATA will create a media and public image campaign to influence the public perception of the trucking industry. This will be important on multiple fronts. It'll support our advocacy efforts, it will educate voters, and it will strengthen the minds of prospective jurors against the reptile before they enter the courtroom. As I'm sure all of you are aware and have experienced, public perception of the trucking industry seems to be at an all-time high with the industry's role in supporting the nation during the pandemic. We are focused right now on ensuring that the appreciation and public support does not go away after the pandemic is in our rearview mirror. So we are trying to find ways to make sure that we continue to show the public and help them understand how important trucking is to keeping America moving. What you can do to get involved, and I think this is the most important part of what I had to say. As you can see, we are attacking this problem from many angles, but we can't do it alone. We need supporters of our industry and people in our industry to get involved. And whether that's participating with ATA or your state trucking association, we need you involved. We need you to get to know your local policymakers. We need you to help them to understand our industry and why this is important. And we also think it's important, if you are involved in a case, to share information, whether it's about the plaintiff's attorney or experts that are used in the case. And we ask that you participate in ATA's Call in Washington program. If you are a member of a state association, you should come with your state to Washington to advocate before members of Congress. And we ask that you always tell your story. I think that is the most important thing, not just to policymakers, but to the public, telling trucking's story. And with that, I'm going to turn it back to Shannon.
Thank you so much, Jennifer. I really appreciate it. It's so interesting. I totally agree with you on sort of it feels like there's been a shift in how the trucking industry is viewed through COVID. It's one of the few benefits that have come out of COVID, and there has been a shift. And before COVID, people didn't really think about or consider how often and how much of an impact on their daily lives the trucking industry plays. And I think that it really it has come out during this time, and I hope that it stays in the minds of people, because it's very underappreciated, certainly. And I hope that also plays out in what we're seeing with these nuclear verdicts. The other thing that I'm so glad you mentioned, I couldn't really find a place for it in mind, but it's that outside funding. Most people have no idea that is happening, because like you said, it plays out in the shadows and they don't know what's happening. And it's such a problem in the industry. It really is an effect in cases, personal injury cases against trucking companies, because those are the ones that have the really big, large verdicts, but they're in all personal injury cases. And it's just such an interesting thing that has sort of come out of these big, large cases. And I mean, it does have a really negative impact of increasing that award. And I really, really hope that we can continue to have the success like what you've seen recently in Louisiana. I think that was really great to see that, and that can spread across the country to really kind of have an outside effort to curb what has been happening in the trend that we've been seeing. So like I've said throughout my presentation, and for what you can do to affect, there's lots of things that affect nuclear verdicts, but what you can do, what you can control is to set up your company to have the defensive safety. And like the quote that I love to say, if you think compliance is expensive, try non-compliance. Well, a $280 million inexpensive non-compliance. Of course, there's a lot of other factors at play, but you can work on safety. And so I think on the next slide, Leah has information about our CSA webinar on the product that we are going to be able to, and what we're going to be able to do for you at Tenstreet to sort of help you make safety easier in your company, and place importance on that, to both have training and an easy way to get training, and to monitor all your data. So I think, Leah, do we have any questions?
Let's see what we've got here. Thank you so much, by the way, ladies. You did a great job. It was so informative and interesting. I'm so happy to have been a part of it. Let's see. And by the way, just make sure, everybody, for joining. Thank you again for being here. You've got a couple handouts to make sure that you can go in there and click on those and download those. And then you have in your chat a way to register for the webinar, the CSA webinar that Shannon was just talking about, as well as the link to the blog that she talked about in the very beginning about the common misconceptions about the clearinghouse. So just make sure you hit on all those before you sign out today while we're waiting for questions to come in. If you have questions, do ask them. They're starting to come in right now. So are there any protections from a court on what kinds of information or evidence a plaintiff can get access to?
So that's a really great question. Yeah, Jennifer spoke, I think, a little bit to it, but right now there's not. If it is even remotely related, I mean, I'm not going to quote the legal standards, or try not to quote the legal standards for what is discoverable. So there's two different things. There's before a trial, which goes through a discovery period where plaintiffs kind of can dig into a company and find out all of their safety practices. That's called the discovery period. And if it is any way, shape, or form remotely relevant to what the plaintiff is looking for to get relief from their case, a judge will allow it. Those are really hard arguments to win when you're saying, no, this isn't relevant, or you can't get to this data or this information. So those almost never win at the pre-trial phase. At the trial phase is a little bit more restrictions, but not a ton. If it relates, the judge is going to allow it in. And I think, as Jennifer said, right now what we see with the evidentiary rules is that all of the information that's allowed to come in is really heavily weighted in favor of the plaintiff. So there's not I would never count on evidence not coming in. I would count on it coming in, and so you want to be in control of that before a case even happens, of what that narrative is and what is happening. So have the evidence that says you placed safety first.
Okay, thank you, Shannon. How about, are there certain states or regions where there's a bigger risk for a nuclear verdict?
Yes. Well, I mean, they can happen anywhere is the truth, but Texas is not a very fun place to be right now. A lot of the nuclear verdicts have come out of Texas. I think it has run a lot of insurers off in Texas. They're really hesitant. The Texas has seen a lot of really big ones. The biggest one, though, the $280 million, happened in Georgia. I think the accident was in Alabama, but they brought the case in Georgia. But it's kind of to what Jennifer spoke to, which is that they the plaintiff's attorneys forum shop, which means that they shop and look for the place that is the most likely for them to get a bigger verdict. And there are legal restrictions on where a case can take place, but plaintiffs have certain options, and they will always choose the option that's better for them on where they think they'll get a better verdict. And so, you know, California, Texas, Georgia, those have seen a lot of the bigger verdicts, those cases in those areas. Jennifer, I don't know if you have any additional things on that, but I definitely think that geography definitely plays a role.
It definitely does. And just jumping in on that, you mentioned California, which is not going to be in the area I'm going to talk about, but generally, a lot of folks that deal with these issues say the states that are the worst to deal with are essentially the crescent from Texas down to Florida. So if you follow that southeastern kind of crescent, that's where you've seen a lot of bad cases, not just trucking, but just in general, high jury verdicts. And part of it is what rules they have in those states. But as Shannon said, you know, it's the plaintiffs are going to try to get into the best jurisdiction they can to get the best outcome they can. But related to that and countering that, we just talked about Louisiana, which has, I believe, the highest insurance rates in the country, and they have some bad verdicts there. They have just passed reform Texas is consistently, the Texas Trucking Association is consistently working on reforms there. And Georgia had a big push before COVID got in the way for reforms in their state. So there's a lot going on with the state trucking associations. ATA is supporting them as they try to push for reforms and improving the environment, especially in that southeastern area.
That is really great to hear.
Okay. So what do you think, if I'm kind of, this is a question for, if I'm kind of getting started in safety, you know, are there some things that are more important to have in place than others, or what's a great place to start?
I would say start with your CSA scores. I would say it's a couple of things. Look at where you are on compliance with the regulations, both for hiring, training, equipment maintenance, all of that. Where do you sit? How well are you doing with compliance with the regulations? And then move on to your CSA scores and develop a plan from there. What can I do to improve my CSA scores? And a lot of that is going to play into training of your drivers, monitoring your drivers and monitoring your CSA scores, and then getting them training and hiring, and then start increasing your hiring standards at the same time, and increase what you're doing to monitor the drivers throughout their tenure with you, as far as NBR monitoring, clearinghouse checks. But I would say CSA scores and training is a really good place to start.
Yeah, and it just so turns out that we can help you with that. So hopefully you have registered for the webinar that we have on the 21st. And you know, if you can't make it at that date and time, we will send you a recording. So just even if you're not sure if you can make it, it's probably, you know, you might want to just go ahead and register because it's free, and it will help you kind of get get started with CSA if you aren't already. And we are a little bit over time, so I wanted to go ahead and wrap things up. But if you do have additional questions, if you think about them later, Jennifer's and Shannon's contact information is up here on the screen right here. You can contact either of them with your questions, or you can just respond to the GoToWebinar email if that's easier. We'll get you to the right place. And I just want to thank everybody again for joining, and thanks Jennifer and Shannon for all your work and everything you've helped and shared with us today. It's been really informative and great webinar.
Thank you.
Yeah, thank you. Thank you so much, Jennifer. We really appreciate it. And thank you all who joined us.
Have a great weekend. Bye-bye.
Bye.